The 63rd session of the Senate in the first regular session of the 17th Congress is hereby called to order. May we remain standing for a minute of silent prayer. Amen. Thank you very much. The Secretary may please call the roll.
Roll call of members. The Honorable Senators Angara, Aquino, Binay, Cayetano, De Lima, Drilon, Ejercito, Escudero, Gatchalian, Gordon, Honasan, Ontiveros, Lacson, Ligarda, Pacquiao, Pangilinan, Poe, Recto, Soto, Trillanes, Villanueva, Villar, Soveri, Senate President Pimentel.
Fourteen senators are present. The chair declares the presence of a quorum. The majority leader is recognized.
Mr. President, I move that we dispense with the reading of the journal of the 62nd session, Tuesday, February 14, and consider the same as approved.
Any objection? Hearing none, the reading of the journal of the 62nd session on Tuesday, February 14, 2017 is dispensed with, and upon motion of the majority leader, the same is hereby approved.
Thank you, Mr. President. We'd like to welcome some guests in the gallery. We have the Sangguniang Barangay of Bambang, Bulacan, Bulacan, headed by ABC President Captain Edilberto Tungca Meneses, and the guests of Senator Subiri, the members of the Night Wolves in Russia, headed by Daniel Foronda, a.k.a. Mumbaki. I would like to welcome them to the Senate.
We make the presence of our guests on record for this afternoon session.
Mr. President, I move that we proceed with the reference of business.
Secretary will read the reference of business.
Bills on first reading. 1327, an act providing for a Magna Carta of the Poor by Senator Sani Angara.
Committee on Social Justice, Welfare, Rural Development, Ways and Means, Finance.
1328, an act providing for the urban and countryside greening in the Philippines, Senator Sani Angara.
Environment, Natural Resources, Local Government, Finance.
1329, an act requiring all national, regional, and provincial government hospitals to establish, operate, and maintain a dialysis ward or unit in the respective hospital and providing free dialysis treatment to indigent patients, Senators Sani Angara.
Health and Demography, Social Justice, Welfare, Rural Development, Finance.
1330, an act establishing a framework for film and television tourism in the Philippines, marketing the industry globally, and providing employment for the sector and for other purposes, Senator Sani Angara.
Public Information, Mass Media, Ways and Means, Finance.
1331, an act instituting inclusive education and the establishment of inclusive education and learning resource centers for children and youth with special needs in all public schools divisions, providing for standards and guidelines and appropriating funds therefore, Senator Sani Angara.
Education, Arts and Culture, Women, Children, Family Relations, Gender Equality, Ways and Means, Finance.
1332, an act creating and establishing the Philippine High School for Sports, Senator Sani Angara.
Education, Arts, Culture, Sports, Ways and Means, Finance.
1333, an act extending the services of a scientist who is due for compulsory retirement for a maximum period of 5 years, amending for the purpose Republic Act number 8439, otherwise known as the Magna Carta for Scientists, Engineers, Researchers, and other science and technology personnel in government, Senator Sani Angara.
Science and Technology, Civil Service, Government Organization, and Professional Regulation, Finance.
1334, collective investment Schemes Law, Senator Sani Angara.
Financial institutions, banks, financial institutions and currencies, trade, commerce, entrepreneurship, ways and means.
Resolution directing 292, resolution directing the proper Senate committee to conduct an inquiry in aid of legislation on the report that there are 550 blood bags that tested positive for human immunodeficiency virus. Senator Maria Lourdes Nancy Binay.
Health and demography. So, Majority Leader.
Mr. President, with the consent of the Chamber, I move for the consideration of PS Resolution 289.
Any objection? Hearing none, consideration of measure is in order.
Before we ask the Secretary to read the title of the measure, I move for a 1-minute suspension, Mr. President.
Session suspended for 1 minute.
We are ready to resume, Mr. President.
Session resumed.
May we ask the Secretary to read the title of the measure without prejudice to inserting into the records the entire text of the resolution.
Resolution expressing the sense of the Senate that termination of or withdrawal from treaties and international agreements concurred in by the Senate shall be valid and effective only upon concurrence by the Senate.
Mr. President, may I move that the President Pro Temp, Senator Franklin Drilon, be recognized to sponsor the measure?
The Senate President Pro Tempore, Senator Franklin Drilon, is recognized.
Thank you, Mr. President. Thank you, Mr. Majority Leader. Mr. President, under Article 7, Section 21 of our Constitution, it provides that, quote, no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate, end of quote. Likewise, Article 2, Section 2 of the same Constitution provides that the Philippines adopts the generally accepted principles of international law as part of the law of the land. Even our civil code provides that, quote, under Article 14, it provides, quote, penal laws and other public security and safety, penal laws and those of public security and safety shall be obligatory upon all those who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations, end of quote. Well, Mr. President, the power to bind the Philippines by treaty or international agreement is therefore vested jointly by the Constitution and this chamber. A treaty or international agreement ratified by the President and concurred in by this chamber becomes part of the law of the land and may not be undone without the shared power put into effect. Mr. President, the principle of checks and balance, historical precedent and practice accepted as law in most jurisdictions, and the Constitution's dictate for a shared treaty-making power require that a termination, withdrawal, abrogation, or renunciation of a treaty or international agreement can only be done with the same authority that gave it effect, executive ratification with the concurrence of the Senate. This is the sense of the 14 senators who signed proposed Senate Resolution 289. I repeat, Mr. President, this is the sense of the 14 senators, namely this representation, Senators Aquino, De Lima, Hontiveros, Lacson, Legarda, Pangilinan, Zubiri, Honasan, Ejercito, Soto, Angara, Recto, Villanueva, and this afternoon, Senator Trillanes is the 15th senator who expressed his support for this sense of the Senate resolution. Mr. President, let me emphasize that this proposed sense of the Senate resolution is only a reiteration of the decision of at least 16 senators when they adopted Senate Resolution number 33, which concurred in the ratification of the Articles of Agreement of the Asian Infrastructure and Investment Bank. In that resolution number 33, which ratified the Articles of Agreement of AIIB, the more than two-thirds of this membership of this chamber resolved that the President of the Philippines may, with the concurrence of the Senate, withdraw the membership from the Asian Infrastructure Investment Bank. This early, or last year, on December 5, the Senate already took the position that a withdrawal from an international agreement such as the AIIB must have the concurrence of the Senate. Therefore, Mr. President, I would reiterate that this is simply a reiteration of that position already taken by the Senate in resolution number 33. The legal question really, Mr. President, is whether the President of the Philippines can unilaterally terminate a treaty has yet to be decided by the Supreme Court. Since the wording of the relevant section in our Constitution originated from the United States jurisdiction, we turn to the prevailing interpretation of the same section in the U.S. jurisdiction. In the United States, scholarly views continue to be mixed. Scholars argue that the framers, at the very least, prescribed a shared role between the executive and the legislative in keeping with the Constitution's principle of checks and balances. Historical practice in the United States also shows that far more often than not, the Senate or the whole Congress has exercised power to approve the termination of the treaties. There have been exceptions, but none support a limitless power of the President to annul any treaty at his sole discretion. Since the Constitution expressly provides for a shared treaty-making power, it necessarily implies that the power to abrogate the same must also be exercised jointly. This position is further reinforced by the fact that the Constitution is silent as to the power of the President to unilaterally terminate the treaty. Mr. President, through this sense of the Senate, it is our submission that the Senate must assert its power as the branch of the legislature involved in our foreign relations aspects of our governance. We must strengthen our institution by expressing the sense of the Senate that any termination of a treaty must have the concurrence of the Senate. It is for this reason, Mr. President, that we urge the adoption of proposed Senate Resolution number 289. Thank you, Mr. President.
Thank you, Senator Tiron.
Mr. President,
The Majority Floor Leader, Senator Soto, is recognized.
Mr. President, will the distinguished President Pro Temp favor us with a few questions?
With pleasure, Mr. President.
Thank you, Mr. President. For the record, at the outset, I indeed confirm that I signed this particular resolution, and I must admit that I do quite agree with the sense. But let me, I hope I can be educated more on the issue at hand, particularly on international agreements. As a matter of fact, there are 2 or 3 other members of the Senate who wish to be enlightened also. So may I know from the sponsor, Mr. President, the President Pro Temp, what are considered as international agreements?
What are considered as international agreements? As distinguished from the international agreement would cover a whole milieu of agreements entered into by a sovereign country. It can be an executive agreement, it can be a treaty, it can be agreements between two departments of governments. In general, this would comprise what we would call international agreements.
Because as we have entitled it, a withdrawal from treaties and international agreements. So, you consider treaties as part of international agreements, therefore, and protocols.
Yes, Mr. President,
same
in fact,
effect.
that is the treaties before its effectivity must be ratified by the President, and that ratification must be concurred in by 2/3 of the members of this chamber.
All right. Therefore, the second protocol that was mentioned a while back, Mr. President, that the Executive Department submitted during the time of President Gloria Macapagal Arroyo was not ratified by the Senate. So how do we classify that particular executive agreement signed by Secretary Bert Romulo, Mr. President?
They classify this as executive.
1 minute suspension, just for consultation, just 1 minute.
Session suspended.
Ready to resume, Mr. President.
Session resumed.
Yeah. Mr. President, when the second optional protocol on international to the International Covenant for Civil and Political Rights was enacted by the United Nations, at that time we could not we could not ratify the same, as we had the death penalty in our statute books. So the death penalty was inconsistent with the second optional protocol to the International Covenant on Civil and Political Rights, which aimed to abolish the death penalty, and therefore we could not ratify it. When we repealed the death penalty in 2006, the position taken by the Secretary of the Department of Foreign Affairs, Alberto Romulo, was that the second optional protocol is an expression of with the enactment of the Republic Act 9345, which prohibited the imposition of the death penalty in the Philippines. The Secretary of the Foreign Affairs opined that the second optional protocol is an expression of the Philippine support for the global community in its efforts to abolish the death penalty. And therefore, the President of the Republic, Gloria Macapagal Arroyo, after having considered and seen the second optional protocol, ratified and confirmed that this and the same in each and every article of the clause thereof. Now, the position of the DFA was that the Senate's concurrence was not needed because the Philippines notification and accession was pursuant to the passage of the law. So the DFA's view was that the passage of the law which abolished the death penalty was the ratification that was needed to ratify the second optional protocol.
And therefore, based on the opinion of then Secretary Romulo, they did not need the ratification of the Senate.
They considered the passage of the law as the ratification. That was the view that they took.
Oh, but the passage of the law was before the second,
No, after.
the second protocol, huh?
No, after. After the
After?
second protocol.
But not
Because that is precisely why we could not ratify the second optional protocol immediately after its adoption, because at that time we had the death penalty in our statute books. It was only when we repealed the death penalty that the ratification was taken, and I would repeat, the view adopted by Secretary Romulo and the DFA and the government at that time was that the passage of the law which
law?
abolished the death penalty
man.
is the ratification necessary for us to accede to the second optional protocol.
Parang mahirap pong tanggapin yun, Mr. President. Ibig sabihin, by implication, implied lang, dahil may pinasang batas, implied na nag-agree tayo sa agreement. Baka iba yung content ng agreement, Mr. President. No, the reason I'm saying this is that this resolution that we are discussing now is the reverse of what happened. We are going to reverse what happened. In other words, pumasok sila ng agreement, hindi ni-ratify ng Senado. Ngayon, ang gusto natin, papasok sila or aalis sila sa kahit anong agreement, kailangan ratified ng Senado.
Ang pagpasok po sa tratado ay nakakalagay sa ating sa legal basis. Our Constitution, however, is silent as to whether or not the concurrence is necessary. And as we said, in the United States, the issue is not even settled. And in the Philippines,
not even
it is not
settled.
settled.
Yeah,
And
all
that
right.
is why we are proposing the sense of the Senate resolution in order to strengthen the Senate in its role as a treaty ratifying body, as in exercise of its shared responsibility in the enactment of treaties.
You practically answered my next question, because the next question was, what does the Constitution say about abrogation? Wala.
There is none.
Silent. All
There
right.
is none.
Now,
And even in the United States, the issue is not settled.
so, has this happened before?
It has never happened.
Even in the other countries?
In the other countries, it happened in the United States several times, but only one was brought to court. At the initial stages, the lower court said the concurrence is necessary. The concurrence of the Senate is necessary. On appeal, the decision was reversed. The Supreme Court, to whom the appeal was further brought, said this is a political question. We don't want to touch it. So that is where it stands now, insofar as the history in the United States is concerned. In the Philippines, I am not aware of any case wherein the executive withdrew from a treaty, much less was there an occasion for the Supreme Court to rule on this issue.
Mr. President, in my opinion, in my humble opinion, by passing this resolution, We are practically saying that the Romulo Agreement is wrong.
Well, not so, Mr. President. The Romulo Secretary Romulo took the position that, in fact, we can accede to the second optional protocol effectively because the passage of the law which abolished the death penalty is in effect an expression of the support of the for the global community in the effort to abolish death penalty.
Okay, Mr. President, there are others who wish to be enlightened on the matter. So I move to recognize Senator Pampilo Lacson, and then Senator Francis Escudero, and then Senator Manny Pacquiao, Mr. President.
Thank you, Majority Floor Leader. Senator Lacson is recognized.
I yield to Senator Pacquiao, Mr. President, because he did not sign the resolution.
Senator Pacquiao is recognized.
Thank you, Mr. President. I just want to have a clarification of this resolution, Mr. President. If my colleague willing to answer some questions.
My pleasure, Mr. President.
Thank you, Mr. President. In our Constitution, Article 7, Section 21, it says, no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. Section 21, we're only given the power to ratify. It means that this resolution gives the Senate the power now to nullify the treaty?
No, the resolution does not give the Senate the power to ratify or to withdraw. All that the resolution is saying, that it is the sense of the Senate that any withdrawal from a treaty must have the concurrence of the Senate before the withdrawal becomes effective. That's all that it says. And as we said, we want to strengthen the power of the Senate in the foreign relations aspect of our governance, as it is the Senate rather than the House who has primacy in foreign relations.
Mr. President, the ICCPR agreement can only be nullified by the concurrence and the resolution by the 2/3 of all the members of the Senate.
I'm sorry, can we have the question again, Mr. President?
If we approve the resolution, the ICCPR can only be nullified by the concurrence by the 2/3 of all the members of the Senate. Is that correct,
The
Mr.
question
President?
is, if we adopt this resolution, the withdrawal from the International Convention for the Protection of Civil and Political Rights can only be effective upon the concurrence of the Senate. Is that the question, Mr. President?
The nullification, Mr. President, in ICCPR, Mr. President, can be nullified by 2/3.
The withdrawal? The withdrawal? The withdrawal of the country from the optional protocol, if we adopt this resolution, the position that the Senate will take is that the withdrawal is not effective unless concurred in by this chamber. The vote required we did not state, Mr. President. It can be 2/3, it can be majority. That is a matter which we decide at a later date. But that we must give our consent is what the sense of the Senate resolution would want to put forward.
Mr. President, it gives more power to the Senate, and it means that our Constitution it's weaker.
No, Mr.
of
President.
this resolution?
Mr. President, in fact, the resolution would strengthen our institution because now we participate in a change in policy of government. When we sign a treaty, when the President ratifies a treaty, and we concur in the treaty, it means that the treaty becomes part of the law of the land. When the President changes his mind and says, we are withdrawing from this treaty, this resolution says you must secure the concurrence of the Senate because that is a change in policy which we participated in, by ratifying the treaty. That's all that it says, Mr. President.
Mr. President,
if it's-
all I know is
Please,
Mr. President, all I know is the treaty cannot overpower our constitution. Our constitution is supreme, meaning I know what is supreme is. It's cannot overpower the treaty cannot overpower our constitution, Mr. President.
this resolution does not resolve the issue of which is more powerful, the Constitution or the treaty. In fact, the Constitution should be more powerful, but we do not indulge, or we will not indulge in that question in this resolution. We repeat, this resolution only puts across the sense of the Senate, the position of the Senate, that this institution must participate in the change in policy. And what is the change in policy? When the executive withdraws from a treaty.
Mr. President, yung binigay sa atin na power ng Constitution, yun lang gusto nating dagdagan parang mag-aamin tayo ulit ng batas, panibagong batas, and we are trying to make a resolution na parang amending the Constitution Section 21 by adding another power to nullify the treaty or the resolution agreement.
I hope that the gentleman is not saying that we should not exert any effort to make the Senate more effective in the conduct of our foreign relations. This is all that the resolution is saying. Give the Senate more say, more power in the conduct of our foreign relations by adopting a sense of the Senate resolution which says that we should be consulted when the President abrogates a treaty. That's all that we're saying. And we want precisely to strengthen our institution in terms of our participation in the conduct of foreign relations, which I repeat is an area that the Senate is superior compared to the House.
Mr. President, I want more conversation about this resolution, so I ask for the gentleman to give us some more time to discuss this resolution in another days. Because
Mr. President, we regret that this is a very simple resolution. There are 14 senators who signed. We have already taken this position when we ratified the Articles of Agreement of the Asian Infrastructure and Investment Bank by adopting resolution number 33, where 16 senators concurred in the position that the President of the Philippines may withdraw from membership of the Philippines from the Asian Infrastructure Investment Bank with the concurrence of the Senate. So this is not the proposed Senate Resolution 289 is not new. In fact, it is only a reiteration of the policy we have adopted in resolution number 33 and concurred in now by 14 senators. 15.
Mr. President, this is not new. This is a new resolution, and this is not a simple resolution. It will. This resolution is. It will effect in our constitution, and this must be discussed furthermore. And that's why I ask more time to discuss about this matter, because it will affect or talk about our constitution. So if allowing us to give us more time to discuss on or
We regret, Your Honor,
study
that
this conversation.
we cannot concur in the request.
Session suspended.
Mani, sige na, simple lang ito.
Sino mauna? Si Ping?
Session resumed.
Mr. President, thank you. May we now, the statement of Senator Pacquiao was not a motion, it was a request. So we can tackle that later. In the meantime, for more enlightenment on the issue, may I move to recognize Senator Pampilo Lacson, Mr. President?
Senator
Thank you.
Lacson is
Thank you,
recognized.
Mr. President. Actually, I requested Senator Pacquiao to do some shadow boxing in the meantime. That suspend his interpellation. Anyway, Mr. President, now that 15 senators of the 17th Congress have signed the resolution expressing the sense of the Senate, and in all probability, this will be adopted because we are already 15 who signed the resolution. My question is, how do we proceed from here?
Well,
I'll be more specific, Mr.
Yes.
President. Since there's no other time in the past, except probably now under this administration, that the possibility of a withdrawal from an international obligation could happen, how do we tackle the issue if it happens?
okay. How do we tackle the issue if, in fact, the President withdraws from a treaty? The leadership of the Senate or any senator can bring the issue to court and assert that the withdrawal is invalid given the fact that the Senate did not participate in the withdrawal, and in fact it is the view of the Senate, if this resolution is adopted, it is the legal position of the Senate that the withdrawal to be effective must have the concurrence of the Senate. That issue must ultimately be decided by the Supreme Court,
So we leave it up to the court, to the Supreme Court to decide.
because it is a legal and constitutional issue, Mr. President.
And since this is just a sense of the Senate
That's
by a
correct, sir.
resolution and has no effect of a law, what chances do we have that the court will side with the Senate?
Well, it is the force of the argument that we will propose before the Supreme Court. The fact that our basic position is that the conduct of foreign relations is basically a shared responsibility between this chamber and the President. And that shared responsibility would include the concurrence of the Senate in the withdrawal from a treaty. And in fact, if we adopt this resolution, we can argue before the court that this is the official position of the Senate of the Philippines.
Anyway, thank you for the enlightenment as always, Mr. President. Thank you.
Thank you.
Thank you, Senator
Senator
Lacson.
Escudero, Mr. President.
Senator Escudero is recognized.
Thank you, Mr. President. Will the gentleman yield to a few clarificatory questions? Thank you, Mr. President. Thank you, Your Honor. Mr. President, Your Honor, may I ask, the resolution seems to be incomplete in that it did not state the required vote. You mentioned earlier that it can be 2/3, it can be majority, but if we're passing such a resolution, we should be clear about what vote we will require, and if at all, what's the basis of such a required vote? Majority of quorum, majority of all, 2/3, very much like ratifying a treaty. What would be the position of the author?
Concurrence of the majority of the Senate is sufficient to take the position that the treaty withdrawal is not valid, so that if it comes to a point where the president withdraws from the treaty, we can take the position that the treaty is not effectively withdrawn, and our position is that that resolution would only require a majority.
Majority of all the members, Mr. President, Your Honor?
Majority of all the members.
May I ask
is
what,
the view.
what would be the legal rational basis for saying majority of all as compared to majority of quorum as compared to
Well-
2/3? Or it's a random number?
It's a random. We can. As we said, the matter was left open. We can amend the resolution if the gentleman will wish. We can state majority of all members present in order to give importance to to give stability to the and support for the Senate resolution. Or we can have it as an ordinary resolution, majority of those present, provided there is a quorum.
Second point, Mr. President, Your Honor, perhaps we should look into it and agree. I'm not necessarily against this measure, Mr. President, Your Honor, but I have not signed the measure yet, the proposed resolution yet. On the point of Senator Lacson, he mentioned where do we go from here. If it were a joint resolution, it will have the force and effect of law, and therefore the President would be bound to follow it. But then again, we know the situation perhaps in the House of Representatives. But if it were a law, Mr. President, Your Honor, if we passed a law requiring the President, before he withdraws from any treaty, in the form of a joint resolution, which as the gentleman knows has the force and effect of law, it would be binding on the President. Would that be would that provide a more sufficient basis for the Senate to actually participate in the withdrawal of a treaty?
Well, this is just a sense of the Senate resolution, Mr. President. This is not a law. Now, if there is nothing in the statute books which says that we cannot pass a law. But my view, Mr. President, is that under our system of government, in our system of government, the Senate has the primacy in the conduct of foreign relations. In fact, the Senate is the treaty ratifying body, and therefore has the primacy insofar as the conduct of foreign relations is concerned, compared to the House, which has primacy in taxation, in private bills, etc. So, in my view, Mr. President, we do not need a law, especially that at this point it is just a sense of the Senate. We are not even binding the President. Certainly, we are not binding the President. He can, even if we pass this resolution, we are not binding the President. We are just expressing an opinion.
I agree, Mr. President, Your Honor. We are not binding the President with respect to a sense of the Senate resolution. My suggestion was perhaps at some future time to indeed clarify, solidify this position of the good gentleman, a joint resolution may be filed, hoping, if not in this Congress, in the next Congress, the House would concur to such a joint resolution.
This resolution will not prevent us from filing a joint resolution in the future. Today, we're just expressing the view of the Senate.
Third point, Mr. President, Your Honor. While the Senate has supremacy over the House with respect to foreign relations by way of giving the Senate the power to ratify treaties, will the gentleman concede that the executive branch has primacy over the foreign relations of any country?
Certainly, we can see that.
And in fact, the only role, if at all, of the Senate would be to ratify treaties that the President decides to submit
And
before the Senate.
participation in the confirmation of ambassadors.
Would the gentleman be aware of the international protocol with respect to withdrawals from treaties? Because my understanding is, when a country withdraws from a treaty, all it takes is the President to inform the body that drafted or is implementing the treaty that the state is withdrawing. And from their point of view, regardless of whatever we say here, whether we file a case, whether we have a sense of the Senate resolution, from the point of view, for example, if it's a UN treaty, the United Nations, they will already accept and respect that withdrawal as an action of a sovereign state. Would that be correct?
Well, firstly, this issue has not been settled. In the United States, a number of treaties were abrogated by the chief executive in the last 100 years. The last one was in the case of the withdrawal by the United States of the Mutual Defense Treaty with Taiwan when the One China policy was adopted. The matter reached the courts, but the courts refused to touch it because that it is a political question. So in our jurisdiction, certainly there is no jurisprudence. No case has been brought to the Supreme Court. Insofar as the treaties that we have entered into, some treaties would provide for a process of termination. And the process of termination would involve notification by one party to the other of their intention to terminate.
Mere notification, and in this
Yes.
case, to be done by the executive branch, either the
yes,
President through the ambassador or Foreign Affairs Secretary.
That's correct. But now we are saying that that notification can be done only when the Senate concurs. Because when we ratify, the Senate concurs. And therefore, it has become part of the law of the land, and as part of the check and balance, we should concur.
So moving forward, Mr. President, again, taking off from what Senator Lacson said, if we pass this non-binding sense of the Senate resolution, and the President, let's say, decides to withdraw from the ICC, that will be effective from the point of view of the ICC, and since this is not binding, the recourse of the Senate, or anyone, any member of the Senate or any private individual, would be to go to court. But from the point of view of the United Nations, insofar as the ICC is concerned, we have already withdrawn
Well, if
our
we-
membership or participation in the ICC. Would that be correct? Unless, of course, the court issues a temporary restraining order, but can the gentleman try to enlighten me moving forward? If the court issues a TRO against the President, after he has already written the ICC, of our country's withdrawal from the ICC, will the court be able to enforce or implement such a
Well-
decision, or it will be a status quo ante requiring the President to withdraw the withdrawal?
No, well, I would suppose, Mr. President, that the United Nations will look into the domestic situation before it finally rules on the effectivity of the withdrawal. They will look at the domestic laws, and if they are made aware of a pendency in a court, in our domestic courts, questioning the withdrawal, I am certain that that circumstance will be taken into consideration by the UN when they receive this notice of withdrawal.
Although that is not provided for in the ICC charter, that they consult first with the domestic law and what's happening there if there's a case filed.
No, I am not saying that they consult. I'm just saying that they will look into the situation domestically.
And let it weigh in, perhaps, Mr. President, but not necessarily for them to withhold decision on the withdrawal because that is clearly a unilateral act of a country following, of course, the procedures for withdrawal.
That is correct, and we're saying that the procedure for the withdrawal should include concurrence of the Senate.
Last 2 points, Mr. President, Your Honor. It says agreements concurred in by the Senate. So, the VFA, if the President decides to withdraw from it, it's the sense of the Senate that it needs the Senate concurrence on the withdrawal.
Did you say the VFA?
VFA.
Yes. That is the sense of the Senate if we pass this.
The EDCA, no.
The EDCA, no, because by decision of the Supreme Court, it is an executive agreement.
Now, my last point, Mr. President, Your Honor, on the point raised by Senator Soto, what is the mother treaty, if any, of the second optional protocol?
It is the International Convention on the Protection of Civil and Political Rights.
And we are a state party to that.
Yes, Your Honor.
And the Senate ratified that.
Yes, Your Honor.
Insofar as the second optional protocol is concerned, that was your discussion earlier with him.
That's correct, Your Honor.
And it is the position of the gentleman that that particular second optional protocol was effectively ratified by the Senate.
Was effectively ratified by the country, and that is the position of the Department of Foreign Affairs. Yeah.
But Mr. President, Your Honor,
What is your relevance?
Sir, did you-
actually, I agree with the gentleman's position because it strengthens the position of the Senate. But I just have very serious reservations with respect to that interpretation because it might be stretched. Our Constitution in the Senate has rules on how to concur with treaties. And I am not aware of any procedure or decision, if at all by the court, that speaks of a concurrence by implication, meaning with the passage of a law, we are deemed to have concurred with the second optional protocol.
Well, that is a position taken by
The Foreign Affairs.
by the Department of Foreign Affairs, Secretary Romulo. Whether or not he is correct is a matter of interpretation.
May I ask, is the second protocol a separate treaty or is it considered an adjunct of the Convention on Civil and Political Rights?
I'll hazard an answer. It is considered as an adjunct. That's why it's adopted in relation to that international covenant. That's why
So,
it's so-called second optional protocol, because it's a protocol attached to the treaty.
So by analogy, it's like the EDCA attached to either the MDT or the VFA, which did not require Senate concurrence because it was not submitted to the Senate for its concurrence, although we passed a resolution that it be submitted to the Senate, if I remember correctly.
Yes, the decision, however, of the Supreme Court is that this is an executive agreement. I do not know whether the court touched on the issue of whether or not the EDCA is adjunct to the Mutual Defense Treaty or the other treaties or the VFA. I am not aware of that.
So if at all the courts, Mr. President, can likewise rule on this issue should it be brought up, that the second optional protocol was not ratified by the Senate when it was adopted by our country, and therefore does not also require concurrence by the Senate since no earlier concurrence was given to begin with.
Well, the position of Secretary Romulo was that the passage of the law which abolished the death penalty is in effect the required ratification of the second optional protocol, since we have ratified already the main protocol, the main treaty itself.
I will not belabor the point, Mr. President. Let
Thank
me
you,
just
Mr.
state on record, I am shaky with respect to the position taken by Secretary Romulo. Number one, because the required vote to concur in a treaty is 2/3 under our Constitution. We cannot simply ratify a treaty by the passage of the law, which requires a lower vote threshold. And number two, the House has no participation in the concurrence of a treaty, and the passage of a law requires the participation of the House when the Constitution itself clearly says it's only the Senate with a 2/3 vote that can concur in a treaty. It would be a ripe ground, perhaps, Mr. President, for the Supreme Court to rule on such a thing as concurrence by implication via the passage of a law. I will submit, Mr. President.
Thank you, Mr. President.
Thank you, Senator Escudero.
Okay, Mr. President, may we recognize Senator Richard Gordon?
Senator Richard Gordon is recognized.
Will my good friend Senator Dillon yield to just a few questions of clarification?
Yes, sir. Yes, Mr. President.
Mr. President, I'd like to ask the gentleman from Iloilo, is there a difference between an international agreement and an executive agreement?
My my layman's response, I'm no expert in international law, Mr. President, is that an international agreement is can cover a whole all kinds of agreements entered into by the country. An executive agreement is entered into by the head of state or head of government of two countries and is part of the law of the land.
It's bilateral. The executive agreement is generally bilateral, and the international agreement speaks of a convention.
Yes, that's one way of putting it. That's correct, Mr. President.
That's the way I'm interpreting it. And
Yes.
you cited the Supreme Court decision that says that the military-based agreement was an executive agreement. Does that have to be ratified?
I am not aware, Mr. President, that the Supreme Court ruled that the military basis agreement is an executive agreement. What I recall is that the Supreme Court ruled that the EDCA is an executive agreement and an implementation of the Mutual Defense Treaty and the Visiting Forces Agreement, and therefore does not need the ratification of the Senate.
That is why I asked that, because I asked that simply because you were really referring to the EDCA
Yes, they were
as an
referring to the EDCA.
executive agreement, because I must have misheard you a while ago, and I just
No,
wanted
no,
to be
I'm
sure.
referring to the EDCA, Mr. President.
And is the EDCA an executive agreement?
That's what the Supreme Court has ruled.
And under that provision, and under the provision of Section 21 in the Constitution, if I'm not mistaken, I believe it's Section 21 of Article 7. It says all treaties and international agreements must be ratified, must be concurred in by the Senate by a two-thirds vote. Is that correct?
To be more precise, Section 21, Article 7 says, no treaty or international agreement shall be valid and effective unless concurred in by at least two-thirds of the members of the Senate.
So would an executive agreement be covered by that provision of the Constitution requiring a two-thirds vote then?
It would appear that the Supreme Court said no, an executive agreement is not covered.
This is where the confusion lies for all students of law, I suppose, because as far as we know, when I was in UP, I remember an executive agreement partakes of the same weight as a treaty, only that it did not go through Senate concurrence. And of course, we have come out here with another third entity, which is international agreement. But in the old interpretation, executive agreements can be done by the president because there was no need for ratification, but it has the binding effect of a treaty. Is that correct?
That is correct in terms of the hierarchy of agreements. Certainly, a treaty is more binding than an executive agreement, which is entered into by the chief executive because that does not require the concurrence and participation of this chamber.
Yes, but there is still no such thing as a hierarchy because it has the same effect as a treaty. It is an international agreement that the chief spokesperson for foreign policy, the political officer of the country, which is the chief executive, has his prerogative and the power to enter into an international agreement or an executive agreement or a treaty, except that in a treaty, because it is a very weighty proposition, or an international agreement, because it is a very weighty proposition, he decides that he wants a treaty and therefore now seeks the concurrence of the Senate. And I'm going into the policy, the principle behind a treaty that requires concurrence, because they want to tell the Senate, they would like, or the President would like to tell the Senate, in fact, ito ang agreement, ito ang treaty, ito ang mga sumusunod na obligasyon natin, and therefore kailangan sundan nyo ng concurrence ng two-thirds vote. Would you agree with that, sir?
Well, the treaty certainly is more permanent in character, and it would call for changes in a national policy or a law, while an executive agreement only enhances and implements a national policy. That's in my,
I guess,
you know, again, I do not claim expertise in international law.
and likewise here, Your Honor, and I respect your opinion, as well as my thinking that, you know, it is still a binding agreement nonetheless, only in terms of weight or in terms of, that's where the thing happens.
Yes, it is a binding agreement.
So, having said that, if it is a treaty and it is validly concurred in by the Senate, and under the provision that all international agreements validly concurred in becomes part of the law of the land, then it partakes now, it converts itself into an ordinary law as part of the law of the land, like an ordinary statute.
Okay.
That's correct? Do you agree with that?
It is, I think the weight of the opinion is that, you know, it's higher than an ordinary statute because it involves relations with another country.
Oh, definitely. Statute is purely domestic or could be international, but in this particular case, there are other parties siding up to it. And that is why if we go against the statute or go against the treaty, there are repercussions in terms of our image or our relations with other countries, because if we just go about doing it and moving away from it or rejecting it unilaterally, it would cause some credibility problems insofar as the country is concerned.
Yes, Your Honor, we agree.
Yes. Now, there is a decision here by the Supreme Court, cited by the Secretary of Justice, Philip Morris Incorporated versus the Court of Appeals. And it says the fact that international law has been made part of the law of the land does not by any means imply the primacy of international law over national law. And that is correct. I agree with that. And I'm sure you agree with that in the municipal sphere. Under the doctrine of incorporation as applied in most countries, rules of international law are given a standing equal,
Yes.
not superior to national legislative enactments, such that in case of conflict, a treaty may repeal a statute, and a statute may repeal a treaty. And thus the principle of lex posterior derogat priori, that which comes last in time, will usually be upheld by the municipal tribunal.
Yes. In fact, I agree with the statement of the good gentleman. If we pass a law that contravenes a treaty,
Contrary, yes.
it means that we are repealing the treaty.
Correct.
Right. And precisely in that situation, the participation of the Senate is very clear, that we participate in a process of repealing a treaty by passing a law which is contrary to the treaty.
In other words, it's the same force as law. It is not superior. It has the same force
Yes,
of law.
it has the same force of
It
law.
can be amended. It can be superseded if we
Yes.
pass a law repealing. So
That is why
well, it is very clear.
The only statement, Mr. President, is that I agree with the statement that when we pass a law which contravenes our obligation under a treaty, it means that we are abrogating the treaty.
That's correct. I agree
If
with
we are
that.
abrogating the treaty, it is because of the act of Congress, and Congress includes the Senate. And that is why the sense of the Senate resolution only says that we must participate in the abrogation of a treaty when the President withdraws from a treaty.
Only in the case of a treaty, there are delicate things that transpire, unlike a law. The delicate things that transpire is if we unilaterally, by law, abrogate the treaty, unilaterally, especially on matters of human rights or matters involving humanitarian law, for example, there is the delicacy that such treaties are published or agreements are published in the United Nations. And all the states look at it, and if we suddenly withdraw from it, there seems to be a question that will come about as if we are not good on our word. Would that be a logical conclusion?
That is why, Mr. President, it makes more sense to pass the sense of the Senate resolution, because precisely we should exercise extra care in withdrawing from international obligations by withdrawing from a treaty.
I just want to clarify that these questions are made to clarify the issue.
Yes, Mr. President.
Because if we abrogate it, then there are repercussions. There are delicacies that, not delicacies, but there are delicate matters that that will affect us. And that is why I signed it.
Thank you,
It
Mr. President.
confers
Mr.
no,
President.
it confers no priorities, it confers no force of law. It is simply the Senate of the Senate. And
Thank
that is
you.
how we must look at it.
Thank you, Mr. President.
Thank you very much.
Mr. President, to continue the points, before I move to recognize Senator Recto and then Senator Angara, I was just informed, and I just found out, that we are a signatory to the Vienna Convention on the Law of Treaties, signed in Vienna in 1969. And in that law of treaties, there is Section 3, which states termination and suspension of the operation of treaties. Ano, ito pala. Termination of or withdrawal from a treaty under its provisions or by consent of the parties. The termination of a treaty or the withdrawal of a party may take place A, in conformity with the provisions of the treaty. Ang dapat pala natin tignan ay yung treaty, kung ano yung treaty nga atrasan natin. Merong procedure pala doon. And then B, at any time by consent of all the parties after consultation with the other contracting states. So, well, I think in that case, we need to look at the possibility of the treaties that we have entered into and how we can terminate or suspend. That will be related to the resolution that we are discussing now. Anyway,
Yes,
for the record,
Mr. President, just in response, yes, we agree, we're aware of our commitment in the Vienna Convention, but that is in relation to the termination by the country. What we are saying is internally, the process is what we should look into as to whether or not the concurrence of the Senate internally is required for us to be able to effectively withdraw from a treaty.
Yeah, well, we
Internal
can surely
process.
look into, let us sample a treaty perhaps so that we can find out. Anyway, I move to recognize the Minority Leader, Senator Ralph Recto, Mr. President.
The Minority Floor Leader, Senator
Thank
Recto,
you.
is
Just
recognized.
very briefly, Mr. President, to the sponsor of this resolution, which I support. Mr. President, just very briefly, what is the difference of an executive agreement and a treaty?
What is the difference between an executive agreement and a treaty? Again, my layman's understanding is that a treaty is more permanent in character. It changes national policy because it creates an exception from a national policy, whereas an executive agreement is a matter between only the executive, only between the heads of state of two sovereign countries, and therefore it only implements a policy.
Yes. And an
In other
executive
words,
agreement-
Mr. President, the President of the Republic cannot sign, the President of the Republic of the Philippines cannot sign an executive agreement which will contravene a national law.
Correct. I agree with you, Mr. President. A treaty would also have an effect of law.
That's correct, sir.
A treaty could be bilateral and multilateral.
That's correct, sir.
An executive agreement, by nature, is bilateral.
That's correct, sir.
And there's a higher standard for a treaty that the Senate has to concur.
Yes, sir.
In the executive agreement, the Senate has no participation.
That's correct, sir.
Having said that, if the President were to abrogate an executive agreement, he did not come to the Senate.
That's correct, sir. In fact, the President, even if it's a treaty, if he does not want the Senate to participate, he withholds.
That is today.
Yes.
And that's precisely why I support the resolution. For practical purposes. For example, the President decides one morning, whoever he or she may be, and suddenly says, let us get out of the Mutual Defense Treaty. Pwede niya gawin yun without a law or resolution from the Senate.
The sense of the Senate resolution precisely says it is our sense that the consent of the Senate should be secured. Whether the President will concur with that or not is a matter
Correct.
that is for him to decide. He
Correct.
can completely disregard the
Correct.
view of the Senate. But at least it gives the leadership of the Senate, whoever that will be, to go
Precisely.
to court and say, with the sense of the Senate,
And I
is that-
support that position,
is that we
precisely the
must
point.
concur.
Because something as important as that could not be decided by one person.
Yes, sir, I agree.
Okay, second point, another example, economically. The General Agreement on Tariffs and Trade, isn't that a treaty?
That's a treaty, if I recall.
That is a treaty. At yan pinag-usapan ng napakahabang panahon din dito sa Senado when we agreed to be part of that the treaty. Now, today, the President can, whoever he or she may be, can wake up in the morning and say, I will abrogate our international agreement and not be part of the WTO. Is that correct?
That's correct, sir.
Now,
It can.
under our resolution, we're saying, teka muna, sandali lang. Kausapin muna rin natin, dapat ang Senado. That is what the sense of the Senate is saying.
That's correct, sir. Dapat,
We were
kausapin
part
muna natin
of-
ang Senado.
Yes.
But let me add,
Yes.
the President can say, up you, we will not talk to you.
Correct, because that is the situation today.
Yes, yes.
So all I'm saying is that, these as examples, it is important that the Senate be heard.
That's correct, sir. That's why I'm glad that the minority leader has that view.
So not only on the issue of the death penalty,
Ah,
but this will cover all treaties. Now, procedurally, if we are saying that the Senate concurs with treaties,
I'm sorry, concurred?
we have to concur
Yes,
to effect a treaty.
yes.
Equally important is that when the chief executive wants to abrogate, dapat, and I'm sure that the framers of our Constitution should have thought of it, and they probably did during the debates, that there must also be concurrence of the Senate,
Yes, Your Honor. That is,
especially if it is a multilateral agreement.
yes, Your Honor.
So I rise to make these points clear in support of the resolution. Thank you very much, Mr. President.
Thank you, Mr. President.
Thank you, Senator
Thank you,
Rex.
Mr. President. Finally, Senator Sani Angara, Mr. President.
Senator Angara is recognized.
Thank you, Mr. President. Majority Leader, with our idol from Iloilo, yield to a few questions.
My pleasure, Your Honor.
Mr. President, may we ask the good sponge, incidentally, I'm a signatory to the resolution, and I support it because it upholds the power of the Senate as an institution and recognizes its power to share in the foreign policy making power. But may I ask at the outset, does the gentleman agree with the Romulo opinion that the passage of a law can be considered concurrence in a treaty?
The difficult question, Your Honor. In other words, where the ratification is implied by the passage of the law, is that a sufficient ratification? I must admit that that is an issue which is subject to various interpretation with equal force.
Mr. President, has the gentleman ever encountered a similar case in the past where the passage of a law by Congress was considered an accession to a treaty, a deposit of an instrument, or a ratification of a treaty or international agreement?
We have not had an opportunity to research on that issue, Mr. President.
It's possibly a case of a first impression.
Yes, it will be a case of first impression. In fact, whether or not the Senate's concurrence in the withdrawal of a treaty is a question also of first impression.
Mr.
Not
President,
even
was,
in the United States has this issue been resolved.
Mr. President, was the gentleman present in Congress at the time when we passed the law repealing the death penalty?
I was the Senate President at the time.
You were the Senate President then. What was the vote of the Senate? Would you remember?
16-1, Your Honor.
Okay. So in that case, perhaps there could be no conflict because the Constitution requires for ratification of treaties, there must be 2/3 vote of all the members,
Yes.
in which case that's a 16. So in this case, there is a congruence between the required constitutional vote and the actual vote.
Yes, Your
But there
Honor.
may be a case that the danger with the Romulo opinion is that for it to be a precedent is that you may have a case where a law was only passed by a majority of all the members, there being a quorum, but it's actually shortcutting the constitutional process, Mr. President.
On the other hand, the law requires the concurrence of both houses and the signature of the President.
Right, but again, it was, as the gentleman conceded earlier, the House has very little role in the conduct of foreign affairs, Mr. President.
Yes, Your Honor.
So again, I agree with the sentiment expressed by the gentleman in his resolution, which is why I signed. But I do, with respect to the second optional protocol, incidentally, Mr. President, is that a treaty, the second optional protocol?
Well, when we crafted this this resolution, as pointed out by Senator Recto, who concurred, this is applicable to all the treaties. The Rome Statute, the MDA, Mutual Defense Treaty Agreement, the BFA, and not only to the second optional protocol, because there will be a lot of debate there, Mr. President, whether or not the passage of the law which abolished the death penalty is the equivalent of our concurrence, whether or not a separate concurrence from the main treaty is necessary. So we can, we need not take into account the second optional protocol in passing the sense of the Senate resolution.
Yes, Mr. President, but I take the occasion to ask about it because it's relevant to current
It is.
debates in the Senate, Mr. President. But I've come across an authority which states that an optional protocol is a treaty that complements and adds to an existing human rights treaty. And I was informed by the majority leader that the Philippines ratified the Mother Treaty, which is the International Covenant for Civil and Political Rights, as well as the first optional protocol. But in a sense, departed from previous practice by only
Notifying.
Incidentally, was the Senate notified of the accession?
The Senate was not notified. The Department of Foreign Affairs notified the United Nations of the ratification by the Chief Executive.
But did not inform the Senate of the Philippines ratification of the second optional protocol.
Sorry?
But did the Department of Foreign Affairs inform the Senate?
No, the Senate, the DFA did not inform its chamber.
So when was the gentleman apprised of our accession to the second optional protocol, Mr. President?
When were we made aware?
Yes.
During the committee hearing on the death penalty bill, when the Amnesty International and the Commission on Human Rights brought this up.
See, I find that very strange, Mr. President, because the second optional protocol itself requires states parties to inform other states parties upon the deposit of other instruments, of an instrument. And yet we do not even inform our policy-making body, Mr. President. So again, it may be tangential to the current resolution, but going forward, it's something that we have to look into. And again, I respect the gentleman very much, and I agree with this resolution. But I find that with respect to the second optional protocol, perhaps there may be some questions raised as to whether we are in fact a party and whether in fact our accession to that treaty was validly entered into, Mr. President, just for the record. Thank you.
Thank you, Mr. President.
Thank you, Senator Angara.
Mr. President, I was mistaken. There are two others who wish to interpellate. Senator Hontiveros, Risa Hontiveros, Mr. President.
Senator
And then
Risa
Senator Laila
Hontiveros
de
is
Lima.
recognized.
Thank you, Mr. President. Good gentlemen, I'd just like to raise one additional point with you, just to make it of record. Earlier, the good majority leader mentioned the Vienna Convention. The Vienna Convention on the Law of Treaties allows a nation to withdraw from a treaty if that treaty contains a provision allowing withdrawal. Hypothetically, could a country withdraw from a treaty if it does not contain language allowing withdrawal?
Well, a very good question. I do not know is the answer. Because there are two schools of thought. One school of thought says that if there is no process of withdrawal as contained in the treaty, you cannot withdraw. The other school of thought says that we are that under our laws, the treaty is merely is on the same level as a municipal or national law, and therefore can be terminated. So it's an open question, Mr. President. I am not prepared to debate that point this afternoon.
Thank you, Mr. President. Even the good gentleman's "I do not know" is very interesting to me, as the good gentleman knows one of the 15 authors of the resolution expressing the sense of the Senate. As a last point on that single point, Mr. President, for example, the second optional protocol does not contain a provision allowing withdrawal. So it might be argued in the case of the first interpretation that does this not mean that the Philippines cannot validly withdraw? Thank you, Mr. President. Thank you, good gentlemen.
Yes.
Thank you, Senator Hontiveros.
Senator Laila de Lima, Mr. President.
Senator De Lima is recognized.
Thank you, Mr. President. Would the very distinguished President Pro Tem yield to just one or 2 points?
My pleasure, Mr. President.
My question is not about nothing on the subject resolution itself, resolution number 289, because I fully concur. That's why I signed. This is necessary. This is desirable, and as the sponsor has put it, to strengthen the Senate as an institution. I'm just really very concerned about the issues surrounding the second optional protocol, because we knew all along that this has been duly ratified, and that's why the books, the records of the United Nations reflect it to be such that the second optional protocol was duly ratified by the Philippines, and that is why it's such ratification, such fact was, I think, considered in saying that the second optional protocol has become in force and effect, and therefore binding on the state signatories. And earlier, it was mentioned, I think twice already, that per the opinion of then Secretary Romulo, this was merely considered as an executive agreement. And an executive agreement is not subject to concurrence. Now, these agreements, these treaties, international agreements, these are ratified by the executive branch and concurred and required to be concurred in by the Senate. So it's really the act of concurrence that the Constitution requires, but not necessarily the act of ratification. And I see I'm looking at the timeline submitted by the Office of the Senate Secretary. I'm not sure who made this timeline from the committee secretary, timeline of the International Covenant on the Civil and Political Rights and its protocols, November 20, 2007, and first, September 22, 2006, second optional protocol to the International Covenant on Civil and Political Rights, signed by the states parties in New York. April 25, 2007, instrument of ratification was signed by then President Gloria Macapagal-Arroyo. November 20, 2007, instrument of ratification was deposited with the United Nations. And there is an instrument of ratification signed by the President, submitted to the UN, and entered into the books of the UN. Now, the explanation of the DFA is the second protocol did not pass through the Senate for concurrences. It was treated by the DFA as just an executive agreement. I'm not sure how many would agree with this. And if it's merely an executive agreement, then that means it's not required to be concurred in by the Senate. And if it's not required to be concurred in by the Senate, then our resolution now, assuming this is adopted, would actually have no bearing because it only pertains to the withdrawal from a treaty or international agreement to which we propose that we also concur in the same manner that we concur in its ratification. So I do not understand. I think there's a lot of explaining to be done by the administration, by the executive department that handled this. Because insofar as the books of the United Nations, we ratified the second optional protocol, and that is what I know all along.
Yes.
So,
Yeah.
but now the DFA is saying this is merely an executive agreement. It's so difficult to reconcile all these positions
Well,
at this point.
that only supports our position that ultimately the Supreme Court will be
Yes.
called upon to decide on this issue. Because it's really a case of first impression, probably.
I definitely agree. And in the meantime, pending any issue that may be brought to the Supreme Court for resolution, then we have to take the position that the purported ratification of the second optional protocol as submitted and entered in the books of the UN is deemed to be regular and valid or
That-
constitutional.
The resolution the resolution on the table that we're talking about is simply a sense of the Senate resolution which says that we must participate in the withdrawal from a treaty. We do not touch as to whether or not the accession to a particular document is valid or not. What we're saying, that is a completely different issue. What is an issue that we're presenting is the authority of the Senate to confirm to a withdrawal from a treaty. That's
Thank you,
all
Mr.
the dissent
Thank you, Mr.
of the Senate.
President. But my other concern here is that if the current administration would agree with the position of the DFA that this is merely an executive agreement, then it can be withdrawn unilaterally by the executive department.
But
And that is
withdrawal-
something
But
that
that withdrawal is still subject to a review by the Supreme Court and a decision by the Supreme Court in an appropriate case brought to the Supreme Court.
I also agree, Mr. President, because this is, but again, that is that issue. And I do not understand why DFA now would take the position that this is merely an executive agreement and after submitting an instrument of ratification. Now, if this was duly concurred in, what is supposed to be the document or instrument that is supposed to be submitted to the United Nations? Is it an instrument of ratification also, or is it an instrument of concurrence? Is there a separate instrument that is required to be submitted to the United Nations? Because I think insofar as they are concerned, the instrument of ratification as submitted to them is the correct act or the correct instrument. And, but then again, I agree with the distinguished sponsor that only the Supreme Court can actually settle all these issues. But in the meantime, I do take the position that the second optional protocol was duly. I also cannot even agree to that it is an executive agreement. Thank you, Mr. President. Thank you, single sponsor.
Thank you.
Anyway, Mr. President, a caveat from Senator Manny Pacquiao. May we recognize Senator Pacquiao,
Senator
Mr. President.
Pacquiao is recognized.
Thank you, Mr. President, for allowing me to ask another question and to manifest I believe that the gentleman from Iloilo has told me earlier that this is a simple resolution. It's not correct, Mr. President. Does the gentleman agree of that? It's not correct that this is a simple resolution.
This is a sense of a Senate resolution which is not a binding law on our country. In fact, it does not even bind the president.
But
it is just a sense, it is an opinion that we are expressing here. That is, it's only binding on the Senate, that's all.
so what I heard earlier, Mr. President, is a simple resolution. That's what I heard earlier. That's why. But if this resolution is a simple, why are we discussing for more than 2 hours or almost 2 hours? So it's not going to be a simple resolution. That's why I appeal, Mr. President, to a good gentleman to give us more time for this furthermore discussion about this resolution, because we need more study and learn more about this resolution.
We regret, with all due respect, that we believe we should vote on the sense of the Senate resolution. If our colleagues will vote against it, fine. But let's decide.
Why we are in hurry, Mr. President, that, I think we need practice some patience here. 1 week is not matter, Mr. President.
May I move for a suspension so that we can discuss this not in plenary, Mr. President?
Session suspended.
We're ready to resume, Mr. President.
Session resumed.
Mr. President, during the break, Senator Pacquiao and yours truly, we discussed it with the sponsor, this President Pro Tem, to give the other members of the Senate time to further study so that we can get the entire support of the entire Senate. With the concurrence of the President Pro Tem, we can vote on this on Monday, Mr. President, and that will give the Senate President time to be here also, because I know he is very supportive of this particular resolution also. So if the President Pro Tem will agree, I will move to suspend consideration of PS Resolution 289, and I will make it the first item on Monday morning, Monday afternoon, Mr. President.
Any objection?
We have no objection with the commitment of the majority leader that it will be calendared on Monday, and that we will vote on it on Monday.
Yes, Mr. President.
Thank you, Senator Drilon. Any objection? Hearing none.
Thank you, Mr. President, and thank you to the President Pro Tem. Mr. President, with the permission of the body, I move to resume consideration of Senate Bill 1279 under Committee Report Number 21.
Any objection? Hearing none.
I move for 1 minute suspension, Mr. President.
Session suspended.
Ito. Sino mag-interpolate?
Manifestation. Manifestation.
Mr. President, I just want to make a manifestation. Nasaan?
Wala pa po, hindi po on session. Cynthia, sandali.
Ito kasi.
Mr.
Majority
President, we
Leader.
are ready to resume.
Session is resumed.
Mr. President, with the permission of the body, I move to resume consideration of Senate Bill number 1279 under Committee Report number 21.
Any objection? Hearing none, resumption of the consideration of Senate Bill 1279 is in order.
Mr. President, this is the Pagkaing Pinoy para sa Batang Pinoy Act. The parliamentary status of the measure is that we are now in the period of interpellation. May I move to recognize the sponsor, the chairman of the Committee on Education, Arts and Culture, Senator Bam Aquino, and to interpellate Senators Villar, Poe, and Senator De Lima.
Senator Paulo Benigno Aquino IV, the principal sponsor, is recognized. To appeal of the period of interpellation, Senator Cynthia Villar is recognized.
Magandang hapon, Mr. President.
Senator Villar.
Mr. President, I just want to make a manifestation with regards to the nutrition program in schools that our Committee on Education is trying to pass. I just want to mention my experience a few years back when I was invited in a school, in a small public school, in a simple town in Iloilo province. Okay. They invited me to the school because I was chairman of the Committee on Agriculture and Food, and they showed me their vegetable garden. They encouraged the students to plant vegetable, and every lunchtime, the mothers will come to cook their harvest and then feed them to the children. And that resulted in the solution of the malnutrition among the students in their public school. And at the same time, more often than not, sumusobra pa yung vegetable for feeding, kumita pa yung school out of their vegetable garden. And I was so pleased. And so when this bill was sponsored in the floor, asking for a budget to finance the nutrition program in a school, I thought that we should, instead of giving the budget to the nutrition program, we should give the budget to the Gulayan para sa Paaralan, because we will be helping the school solve their nutrition problem. Okay? The reasons behind the support for Gulayan sa Paaralan, instead of sponsoring a budget for the nutrition program in the school, is that we will make farmers out of our students early in life, especially in the provinces. We will be able to encourage the students to engage in agriculture. Remember, the opinion of the United Nations Food and Agricultural Organization is that the family farms will feed the world, not the corporate farms. And so we have to preserve the family farms. There are 500 million family farms in the world, and we should encourage our students to continue their family farms. In addition, our government doesn't have to spend for a nutrition program. The schools will solve their own problem of malnutrition on their own through the Gulayan para sa Paaralan. And so we will give our budget to the Gulayan sa Paaralan instead of giving the budget to the nutrition program of the government. I have been watching this program of Gulayan sa Paaralan in our public schools in our city, and I don't see any support to this. They just have a program, but they do not support the program. So how can it be successful? And we encourage also our people to be self-sustaining. Hindi yung pag may problema, hihingi agad ng pera sa gobyerno. Dapat, if they have a chance to be able to solve their own problem to their own efforts, then we should encourage them to do so. And then we will be able to contribute to the development of agriculture of our country, for after all, we are an agricultural country. 1/3 of our population are farmers and fisher folks, and another 1/3 of our population are indirectly dependent on agriculture. And for that reason, we should do our best to support our agriculture, even in the schools, so that we can make farmers out of students in our school. Yun lang po. Marami pong salamat sa inyo, Mr. President, at sa ating sponsor. Thank you.
Yes, Mr. President, if I may be allowed to respond. Firstly, we thank the good lady from Las Piñas for her comments. No? She, of course, was the previous chairperson of Agriculture, and we value her comments very much. In fact, Section 8 of the bill talks about the Gulayan sa Paaralan program. But instead of just focusing on one program, we actually included all of the current modalities of feeding programs done successfully in the country. So there's modality for a centralized kitchen in public schools. There's a modality for a centralized kitchen with the local government. There's a school-based, and there's a Gulayan program also. In short, Mr. President, currently, the bill allows for different modalities in different areas, and it's really more of a statement of principle that government needs to get into this nutrition program. The exact modality, we're leaving that to the particular locality, and DepEd, of course, and the NNC, and the body that's created to oversee this to determine what's the best modality for them. But I am also quite aware of the Gulayan sa Paaralan programs. It is a wonderful program, not only in Iloilo, but also in multiple parts of the country. They're usually done on their own without any support from the national government. and it's done successfully. So in short, Mr. President, if in the end, the decision of the implementing agency is to focus on gulayan sa paaralan, then the law will allow for that. But if in the end, some areas will have the gulayan, maybe some of the more urban areas will have a centralized kitchen style, then the law currently allows for that, Mr. President. Now, during the period of amendments, if it's the wish of the good lady from Las Piñas to focus on a particular modality at the right time, we could probably discuss that as well, Mr. President. Thank you very much.
Mr. President, I just want to interject. I don't believe that Gulayan sa Paaralan is successful in many schools in the Philippines. I think it's a program, but it's not very well supported. I have been to many schools in the Philippines. They don't give emphasis to it. So I want, if you want to make this nutrition program, I want you to emphasize Gulayan sa Paaralan and help Gulayan sa Paaralan so that it can be done in all the schools, especially the public schools in the Philippines.
Well noted, Mr. President.
Thank you. Yes, Majority Leader.
I move to recognize Senator Grace Poe.
Senator Grace Poe is recognized.
Thank you, Mr. President. Will the senator from Tarlac yield to a few questions?
Definitely, Mr. President, as we know that this is Senator Poe's personal advocacy for the past 4 years and has been our, one of our, if not the main partner for this bill.
Thank you, Mr. President. My first question is, it is an established principle that laws must provide minimum standards for their implementation and state the implementing agency. This being the case, may we clarify with the sponsor the number of days the proposed national school feeding program should be implemented? Section 3 of the bill is unclear on this matter. So how many days will you have the school lunch program? It was my hope, at least in my version of the bill, Mr. President, that it will be for the entire school year.
Mr. President, we're very amenable to the suggestions and the recommendations of the good sponsor, the good co-sponsor. So at the right time, we can amend to include these concerns.
And also, who will be included in the program? Is it all students? From what level to what level? Is it the ones with special needs, or will it be the entire student body of the public school?
The goal, Mr. President, is really to include everybody, no? Because currently, the groups handling nutrition in our schools are moving away from just the malnourished towards the malnourished and the stunted. And that actually includes a larger number of students. Now, you go from about less than 2 million to about 6 million. So the scope is quite larger, Mr. President, but what we did here as a statement of principle to ensure the nutrition of our students and allow the implementing agencies to limit it during the implementation phase. So we didn't want, Mr. President, to limit that here, because if in the end we can actually provide for all of our students, then that would be great, no? But as you and I probably know, the implementing agencies will probably limit this further towards those who are, hopefully, to more than what we're doing now, which is just the malnourished. We're hoping that we can do at least the malnourished and the stunted, and even move up to a larger scope if we can do it, Mr. President, through our budget or through the programs in the schools.
Actually, Mr. President, I think that is a good analysis also of the senator from Tarlac. Right now, aside from the stunted or the aside from the severely wasted, if we just increase it to the stunted children, that will almost be half of the student body population. That's how many Filipino children are stunted, and we are probably the top 2 in Asia with the number of stunted children. So even if they start with that first, depending on what the capability is, I think that the bill should at least include a goal that eventually, when the government can afford or the government can have the capability to, it has to include all levels from grade school. Is it grade school or high school?
It's both, Mr. President.
Both? Okay. Well, maybe we can have a tier program that will begin first preschool until grade school, and then later on high school.
Mr. President, we intend to put a provision on progressive implementation, which will allow the implementing agency to determine based on budgetary constraints, what scope they can tackle. However, we really look at the bill more as a statement of principle that we institutionalize that government should take the lead in terms of providing nutrition to our students at the public schools.
Another thing, and also a point maybe related to the point of Senator Villar, for the Gulayan program, if the government focuses and supports this program, perhaps we can give a research of the best indigenous vegetables for each area so that we don't really have to pay too much in fertilizer or growth time.
We can include that recommendation in Section 8 on the Gulayan, Mr. President, at the right time.
Okay, so that's all, Mr. President. I would like to thank from the bottom of my heart the good senator from Tarlac for giving this priority. It languished during the last 16th Congress because we didn't really even have a public hearing for this, or at least I don't recall having one. But I think that the Philippines, with 103 million people, and the majority of our people, or the average, is 23 years old. 34% are ages 1 to 17 years old, something like that. This is certainly an investment for the future. And I don't think this is something that we should skimp on as we spend for infrastructure, which is important. This is a long to medium term investment for us. And I think that it is upon us now to have that privilege to be able to institute a program that will truly empower the Filipino race in Asia and in the world. We always talk about manpower and how the Philippines has one of the best manpower capabilities in the world. But if our children don't grow up smart because they're hungry, then we're not tapping into that resource. And that's the reason why I'm pushing for this, not for anything political. I think that this is something that is legacy-based for all of us. That's all, and thank you, Mr. President.
Thank you, Mr. President.
Thank you, Senator Paul.
Mr. President, Senator De Lima originally signified her intention to interpolate, but subsequently withdrew that intention. But Senator Pacquiao has signified his intention to interpolate. May I request for 1 minute suspension?
Suspended for 1 minute. Can the page request Senator Pacquiao to come to the hall? So session is suspended. Sinabi niya? Sinabi niyo na?
Mr. President, we are ready to resume.
Session is resumed. Senator Pacquiao is in the hall.
Mr. President, Senator Pacquiao has withdrew his intention to interpolate. Considering that there are no other senators who have signified to interpolate, and with the permission of the good sponsor, I move to suspend consideration of Senate Bill number 1279 under Committee Report number 21.
Mr. President, 1 minute suspension, Mr. President.
Before that, can we confirm from Senator Pacquiao that indeed he has withdrawn his reservation on interpolation, just to confirm?
Yes,
For
Mr.
the
President,
record.
I withdraw my interpellation. Thank you.
All right. Session is suspended for 1 minute.
Ready to resume, Mr. President. We just clarified something.
Okay, session is resumed.
Mr. President, there are no other senators who wish to interpolate. I move to terminate the period of interpolations.
In objection, hearing none, the period for interpolation on Senate Bill number 1279 is hereby terminated.
Mr. President, I move to suspend consideration of Senate Bill number 1279 under Committee Report number 21.
The consideration of Senate Bill 1279 is suspended.
Mr. President, with the permission of the body, I move to resume consideration of Senate Bill number 1304 under Committee Report number 28.
1, 3. Okay. Consideration of Senate Bill 1304 is in order.
Mr. President, this is the proposed measure on the free higher education for all act. The parliamentary status of the measure is that we are now in the period of interpellation. May I move to recognize the sponsor, the chairman of the Committee on Education, Arts and Culture, Senator Bam Aquino, and to interpolate in the following order, Senators Gordon, Gatchalian, and the minority floor leader, Senator Recto.
Senator Benigno, Paulo Benigno Aquino IV is recognized as the principal sponsor. Senator Gordon is recognized to avail of the period of interpellation.
Mr. President, we will be looking for those who signified their intention to interpolate, so may I move for 1 minute suspension?
We see Senator Gatchalian here. Maybe we can have Senator Gatchalian instead of Senator Gordon.
Yes, Mr. President. Mr. President, I move to recognize Senator Gatchalian.
Senator Gatchalian is recognized on the period of interpellation.
Thank you, Mr. President. I just have a very few clarificatory questions, Mr. President. First of all, I would like to laud the good sponsor for shepherding this bill up to this point, and this is really a landmark bill that will transform the system of our higher education institutions. But I have a few clarificatory questions regarding the bill, Mr. President. First of all, in Section 4D of RA 8292, or the Higher Education Modernization Act of 1997, the SUCs are allowed to raise tuition fees. And the said bill also gives the SUCs academic freedom in terms of determining policies and tuition fees. The proposed bill, Senate Bill 1304, allocates funds to the SUCs, and these funds are meant to pay for the tuition fees of the students in their own locality. Mr. President, I just want to know what are the mechanisms that what are the mechanisms that are in place to prevent the SUCs from arbitrarily increasing their rates or increasing their tuition fees in order to get more allocations for their schools?
Mr. President, firstly, I'd like to thank the gentleman from Valenzuela for also shepherding this bill. This is actually, for the record, one of his personal advocacies, and we've been partnering with the good senator in his office to make sure this bill gets passed. Just to put it on the record. Mr. President, I'm checking now with CHED because my understanding is that there's an internal process for allowing for CHED to check on the tuition fee increases. We're just currently trying to understand how this works. But in the meantime, Mr. President, CHED does have a process by which they allow or disallow tuition fee increases, Mr. President. So that should be an internal mechanism. Now, if we need to state that in the bill to make it clear that there is a check and balance for the increases of tuition fee, we're amenable to an amendment to make it clear, Mr. President.
Thank you, Mr. President. In the past, I've observed that a lot of the SUCs would increase their tuition fees to cover their operations. And partly because also a lot of the students cannot pay the tuition fees. So to cover that shortfall, they will increase tuition fees. But this bill now will completely pay the tuition fees
Yes, Mr. President.
to the SUCs. And I'm just afraid that some of the SUCs, in order to get more revenue, they might be tempted to increase the rates of their tuition fees.
Yes, Mr. President, we can probably include an amendment to ensure that that doesn't happen. Maybe, Mr. President, an amendment eventually to make sure that the SUCs need to go through a process before they can increase tuition fees, in the same way that we are asking them to go through a process to increase their capacity. So we could probably put it in that provision, Mr. President, especially now that we are actually paying for all of the tuition fee. I think it is within our purview to put that in, Mr. President.
Thank you, Mr. President. I think maybe in the right time we would propose some more mechanisms in order for the SUCs not to abuse this academic freedom or this leeway in increasing the rates.
Yes, Mr. President.
Mr. President, I have my last question is regarding the receivables of the SUCs, and in fact, during our committee hearing, we demanded information from the SUCs and CHED, but unfortunately, they did not provide us with information at that point in time. I'm just wondering, Mr. President, whether they have provided data on the accounts receivable of the SUCs, meaning if how many students are not or cannot pay their or are not able to pay their tuition fees, so instead they would issue promissory notes or any instruments that will enable them to pay in the future. Did we manage to get that number?
No, Mr. President, CHED did not provide that data, but we will reiterate, anyway, the representative is here, we will reiterate that request.
Right. Thank you, Mr. President. Mr. President, also another thing, this actually is connected to the accounts receivable because definitely the amount the SUCs remit or the amount that the SUCs collect from the students is about 8 billion pesos. But did we manage to compute the total revenue or the total tuition fees that is supposed to be paid by the students, if ever they paid completely?
Yes, Mr. President, interestingly enough, the number is quite far from 8 billion. It's actually closer to 16 billion, Mr. President.
So is it safe to say, Mr. President, that the accounts receivable is about 50%?
Mr. President, I had the same thoughts. If that actually meant that the students are only paying half of the tuition fee. To be frank, Mr. President, a cursory look will yield that conclusion, but maybe we can ask CHED to provide better information on that matter.
Because that will determine the sustainability of this program, Mr. President. Definitely we allocated 8 billion this year, and 8 billion was, I think, was based on the actual payment of the students. But definitely there are a lot of students who cannot pay, so they issue promissory notes promising to pay in the future.
Actually, Mr. President, that furthers our argument that the majority of students in the SUCs really are either poor or near poor. No, I think we had a chat about this previously, and if indeed half of them cannot even pay the average tuition fee of about 6,000 to 8,000 pesos per semester, then we know that indeed this is a group that needs help. However, Mr. President, we will endeavor to get better data for you, but a cursory look will indeed conclude that a number of them are not able to pay even the low tuition fee rates that they're already being charged.
Assuming, Mr. President, that everyone can pay, no, has the capacity to pay, so the potential revenue from the students is about 16 billion pesos.
Mr. President, that's our current computation.
And that means that every year, to sustain this program, we need to allocate at least 16 billion pesos.
Yes, Mr. President.
Mr. President, another issue about accounts receivable. Since if ever this bill becomes a law, will the accounts receivable of the students, is this a prerequisite for them to avail or to get into this free higher education program?
No, Mr. President, we currently do not have any provision regarding current debts to the schools.
So that means they have to still pay.
Currently, Mr. President, that is the version that we have.
Okay. Mr. President, there's any intention of condoning the accounts receivable or the debts our students incurred?
Right now, Mr. President, there's no intention unless this would be a provision that you would like to, the good gentleman would like to propose. But the scope of the bill, Mr. President, is forward-looking and not really regarding previous debts in previous years.
All right. Thank you, Mr. President. I would like to iterate the information, the data that we need from CHED, because this is really vital, Mr. President, in determining the sustainability of this program, as well as to determine really how many students, because in I think two or 3 days ago, some of the secretaries issued a press release that only 12% of students enrolled in our SUCs are actually poor. But if you look at the information, only half naman can actually pay. So even though if they're not in that category of poor, but they cannot pay. So this information is very vital to determine really the demographics of our students in our SUC. So I would like to reiterate to compel the CHED to give us those information, Mr. President.
And, Mr. President, let me take the time to also address that issue that you raised. Now, we all know that some of the economic managers wrote a position paper regarding our bill, and to be frank, Mr. President, I take exception to their use of anti-poor, because I think it was not used in the proper context. I don't know where anti came from, considering that when you say anti, it means you're against. That was a leap of logic for me, Mr. President, when they used the word anti. Now, we will agree with them that only about 12% of the poor are able to get to our SUCs. Totoo naman po yan. That has never been a question, But the gentleman from Valenzuela's data, which of course he independently gets, and as well as my office, which we independently get, show that the next 7 deciles, the next 7 deciles of students, so roughly about 70% of the students are in the category of being financially challenged or near poor, as the gentleman from Valenzuela uses, which is a parlance used in the social development circles, the poor, the poorest of the poor, and the near poor. So, Mr. President, that was one blind spot in that position paper of our economic managers, failing to see that the majority of students in our SUCs are in that category, which is your poorest of the poor, and near poor. And if you look at that set, Mr. President, that's an overwhelming majority of the students, and these are students who need help. Kailangan ng tulong. At yun yung gusto ho nating tulungan, which is why, para sa akin, Mr. President, of course, everyone is free to have their own opinion, but if you look at the analysis, also from NEDA and from PIDS, it's clear that the majority of students are those that need the help. And what we're really debating about is the modality by which we provide the help. And the current senators, Mr. President, who have either co-authored this or co-sponsored this are already at 11. No? So, in short, Mr. President, isang boto na lang, pasado na to. And what we have chosen as a modality is to provide the benefit outright. And I think what they wish to do is really to go through a process. And again, it's really a school of thought. Senator Zubiri recently sponsored the Ease of Doing Business Bill, which is basically, kung gagawan rin tayo ng serbisyo sa taong bayan, gawin na natin in the simplest way possible for our people to receive these benefits and this support. In the same way, Mr. President, that I think is the spirit of why we want to have the tuition fee as free at the SUC level, not anymore through scholarships, which will undergo numerous processes. And we all know this, Mr. President, a number of students come to us saying that the scholarships that they're supposed to get come late. Late na, dumating yung pera, tapos na yung panahon ng bayaran. So, we want to skip all of these hassles, Mr. President, make it easy for those that we want to help, and propose this modality where upfront, yung tulong na gustong ibigay, na ibigay na kaagad, Mr. President.
Mr. President, I share the sentiment of the good sponsor that I really don't know where the anti-poor came from, no? Because both of our information validates that almost 90% of our students who go to SUCs are considered below middle income, which is the near poor category. So meaning one shock, magkasakit lang po yung nanay, magkasakit po yung tatay, magkasakit yung bata, they're out of school. And that can be demonstrated with the accounts receivable of the universities, because half of our students who go to our SUCs cannot pay their tuition fee. So even though nasa middle low income sila, hindi pa rin sila nakakabayad at hindi siguradong makakabayad. So this is really a laudable program, Mr. President, and I do again commend the good sponsor for shepherding this bill up to this point, and that no further questions, Mr. President. Thank you.
Mr. President, likewise, we would like to congratulate our Vice Chairman for also taking a lead with this bill. Maraming salamat, Mr. Chairman. Mr. President.
Majority Leader.
Mr. President, I move to recognize Senator Dick Gordon.
Senator Gordon is recognized.
Thank you very much, Mr. President. Will the gentleman yield for a few questions?
Definitely, Mr. Chairman. Mr.
Thank
President.
you very much. I congratulate you for a very good bill. I just want to make sure that we make sure that all the rough edges are smoothed out. First of all, what is published in the papers and in the budget is that we have a 16 billion peso appropriation. Is that correct?
No, Mr. President. We have an 8.3 billion.
In two tranches.
No, Mr. President. For the current year's budget, it's 8.3 billion pesos for free tuition, Mr. President.
1 minute suspension, please.
1 minute suspension.
Ready to resume, Mr. President.
Ready to resume, Mr. President?
1 minute.
1 minute.
That's why initially, when we budgeted for 8.3, we actually thought it was already 8.3. And then we computed around 15, that's why we put 15. But we will amend it to actually put 16, which is the closer amount. That's the average tuition fee times it out.
We're ready to resume, Mr. President.
Session is resumed.
Thank you, Mr. President. I am told by the sponsor that the accounts receivable, including what is appropriated, is 8.3 billion. So in effect, you really have 16.3 billion because the receivables are due to the fact that the students are not paying. Some of the students are not paying. Is that correct?
Yes, Mr. President.
So that is why in the proposed legislation, you have here a budget of 15 billion.
Yes, Mr. President, when we put the bill together, that was just a rough estimate. We intend to put a closer number, Mr. President, to the actual need, which is closer to 16 billion.
So this is work in progress.
For that particular provision, Mr. President.
Yes. When are you going to find out? Because once the bill comes out, it's either 15 or 8 billion.
Mr. President, the 8.3 is already in the GAA. That's allocated for this year. We can actually use that, Mr. President, for the first semester of the 2017 to 2018 school year. Once we pass the bill and we're able to appropriate another, the balance of that, Mr. President, we can use that for the balance of the 2017 to 2018 school year. And then in the succeeding 2018 budget, we can already fund for a full implementation of this law, Mr. President.
Yes, thank you. And I'm keeping my fingers crossed for that.
That's up to us, Mr. President.
Yes. Now, in Section 4, it says eligibility to the full tuition subsidy. All Filipino citizens are either currently enrolled at the time of effectivity of this act or shall enroll at any time thereafter in course in pursuance of a bachelor's degree, certificate, or any comparable undergraduate degree in any SU shall qualify for a full tuition subsidy, provided they meet the admission requirements of the SUC. Provide further that all SUC shall create a mechanism to enable students with the financial capacity to pay for their education in the SUC to opt out of the tuition subsidy or to make a donation to the school. It would appear as if it is the SUC that is applying, not the student, because they're going to set the standards. There is no direct line for the student to apply for the subsidy, but he has to go through the SUC.
Mr. President, the modality that we have chosen here is to have an outright tuition fee subsidy for all the students enrolled in the SUCs. The two schools of thought there, Mr. President, is either we have an outright subsidy, and then those that can afford can opt out and in effect make a donation to the school, or we have everyone apply for a scholarship, which we felt, Mr. President, at least the Vice Chairman and the Chairman of the committee felt would be expensive, would be cumbersome, and would again be mired in bureaucracy and patronage. So we opted, Mr. President, not to have the usual, which is you apply for a scholarship, you show that you only have one TV set or one refrigerator. Instead, Mr. President, to have an outright tuition fee subsidy for everyone, and then those who are above a certain or who belong to a certain income bracket can then be asked to opt out on their own the program of government, Mr. President.
Why would they opt out?
Because, Mr. President, we will make it clear in the enrollment procedure that this is really meant for those that cannot afford. And in previous
That cannot afford.
interpolations, yes, in previous interpolations, Mr. President, we are zeroing in on that number, Mr. President, that we intend to include in Section 4 to determine whether you can afford or not.
In
So
other words,
currently-
when you look at Section 8 requirements for SUCs in relation to Section 4, it says SUCs are hereby mandated to fulfill the following before accessing the fund. Establish a qualifying mechanism, so that's SUC,
yes,
which shall be meritocratic and equitable. This shall include but not limited to a qualifying examination and an affirmative action mechanism for financially disadvantaged students. I think you are trying to create a mechanism for financially disadvantaged students when you actually mean poor but deserving students.
yes, Mr. President, we can use poor but deserving, Mr. President.
Because I think that you really have to be very clear. Otherwise, a lot of people will claim that they're disadvantaged, but and even if they are disadvantaged, they do not exert an effort.
The difficulty, Mr. President, with although, Mr. President, we will welcome an amendment when the time arises, but just to also mention the current debates we've been having with the executive department, there's currently a debate on the definition of poor. Because, Mr. President, NEDA, for example, has come out with a statement that says that very few poor are in our SUCs. But when they say poor, they refer to poorest of the poor, or the D or the E socioeconomic class, roughly with an income of less than 15,000 pesos per annum. Per annum, Mr. President. So it is an extremely low income level. While in the interpellation of Senator Gatchalian, Mr. President, we established that up to 90% actually are of the poorest of the poor, poor and near poor category. And these are all definitions, Mr. President, that our economic managers use, which is why we opted for a broader financially disadvantaged term, Mr. President.
Well, I think we can do that in the amendment, no? But nonetheless, the principle must be very clear. It should be poor but deserving students who should require it. On the other hand, on your Section 8, you have requirements for the state universities and colleges to access the fund. In other words, they have to access the fund, the SUCs.
Yes.
And somehow the student is part of a player lang siya doon, no? Hindi siya masyado nakakadiretsa. Meaning to say, he gets a qualifying exam and affirmative action mechanism for financially disadvantaged students. That's what we were talking about earlier. But upon the other hand, you still have to make sure that it seems that more than the qualification of the student, what is being shown here are demographics, which scares me.
Okay.
No, because kung demographics, hindi talaga na-address yung talagang individual student. That is my point. No? I know you're headed towards the right direction. I just want to make sure we clarify that later on.
Yes, we would welcome suggestions and amendments, Mr. President.
Also, it also says some of the standards that they're saying says publish the maximum standards that the SUC can accommodate. That's kind of a very iffy situation. Why are you doing that on the basis of what they can accommodate? Anong ibig sabihin nun? Kung nandun yung bata at magaling, based ba yun sa maka-accommodate? Because that's very questionable because sometimes may mga favoritism na nagaganap dyan.
No, in fact, Mr. President, the current intention is really to provide all students the tuition fee subsidy, so as to make sure there is no patronage and no favoritism, Mr.
Well,
President.
take a look at this. Submit the following documents, the SUC, that is, to assist the CHED in implementing this act.
Oh, Mr. President, I'm
What
sorry.
is the previous enrollment rate? Student demographics and other relevant information.
Yes, Mr.
What is
President.
the graduation rate, performance, and peerage? In other words, the SUC is being made to qualify instead of the student.
Mr. President, I'm sorry. Now I understand the concern. Mr. President, this is because we also had to address some issues regarding the quality of education of the SUCs and for them to also provide basic data. The most basic here, Mr. President, is their capacity. Currently, Mr. President, it's
Capacity for what?
number of students that they can accommodate,
Okay.
Mr. President.
All right.
Currently, even CHED is having a hard time determining how many students can be enrolled in a particular SUC. And the concern, Mr. President, of the number of our colleagues was that if you don't have a capacity check, then the SUCs could be enrolling 3 times, 4 times in what they can handle.
This is my point. My point is, if it's capacity, you really are talking about teacher to student ratio.
Among others, Mr. President, classroom to student ratio.
Oh, dahil kung masyadong
curriculum.
marami, hindi na matututo yung
Yes,
bata, hindi na
yes, Mr.
makakapag-participate, di ba?
Yes.
So those are just some of my concerns that I think we should be clarifying, di ba? Or for that matter, ano yung gross tuition receipts, teachers' welfare and performance training profiles. Well, that is good for the qualifications of an SUC. What has that got to do with the kids that are enrolling? Your objective is to make sure that the kid who needs to get an education gets involved, and he doesn't want to get involved in the travails of an SUC if they cannot submit the requirements that are being
I see.
that
Mr.
are being
President,
demanded of them.
you're saying that these requirements are superfluous
I agree.
to the intention. We can take a
Touche.
second look at this, Mr. President.
Touche. Also, when you start talking about strengthening student financial assistance programs, you talk about the CHED through UNIFAST, whatever that is, I think I have a pretty good idea what it is, but again, I don't
Yes,
know, we
Mr.
have made definitions here. Shall strengthen all scholarship grants and aid, student loans, subsidies, and other incentives to other educational expenses and cost of living allowance that will be incurred by students in pursuing higher education in SUCs. Moreover, SU5 programs shall also be made available to cover the cost of tertiary education, fully or partially, to students who wish to pursue tertiary education in either HEIs or TVIs. My concern there is there's not enough guidelines on when the student will pay. Are there any guidelines when they will pay this?
Mr. President, this Section 11 actually refers to the UNIFAST law, which we already passed. The guidelines and mechanisms are actually in that law. We can include here probably a reference to the RA, Mr. President, but we just put this here, Mr. President, because we wanted to assure the public that this tuition fee subsidy will not be to the detriment of current scholarship programs already being enjoyed by our students. So this is an additional scholarship program, Mr. President. A number of those programs are found in the UNIFAST law, which was passed in the 16th Congress.
Well, I wasn't there. I mean, that's the accounts for what I'm short on that information. But I'd rather that be explained in detail as well,
Okay.
so that there will be no ground for saying, oh, we misunderstood it and it was not clear.
Okay.
Apart from that, I'm sure you are aware that in my time as serving our country as leader, as mayor or whatever there is that I've done, and I always believe that nothing good is easy to get. That always you have to make sure that people don't think that it is a handout, that you have to work for it. And that is why I am saying that, you know, as Cheryl would say, bo choy kang bo tansha in Chinese, which means you don't work, you don't eat.
Okay.
All right? And if we mean to say that, I don't want it to, again, send the idea that the government is a Santa Claus, that it is handing out all these goodies, and then the student doesn't seem to be challenged anymore.
If I may clarify, Mr. President, the tuition fee subsidy is about a 30% reduction in their costs.
Mhm.
It's not even a majority of the costs of a student, Mr. President.
Doesn't matter.
No, all I'm saying, Mr. President, it's not a complete dole-out because they still have to pay for their education.
Doesn't matter, because I think in other countries, for example, and our tuition fees are one of the lowest. The only other guys that are lower than us is Cambodia and I think Indonesia. Are
In
you
the
aware of that?
ASEAN, in the ASEAN.
Yeah, well, I think I have some research on that, and for the benefit of the debate, because we will have to take a look at that. The tuition fees of some countries, include China, is $2,000, $4,000 per year. India is $370 per year. Korea is $3,500 to $8,000 per year. And it is reflected in the grade school and high school also, where their teachers are paid very, very well. So anytime we can get back some money so that we can pay our teachers better, it's important. Cannot be seen as a handout. Of course, the United States is $30,000 per year. Some say it's even $100,000 per year for college. United Kingdom is $7,500. Now, when you go to the ASEAN countries, $430 for Thailand. I'm sorry, $8,500 per year. Singapore is $10,500 per year. It's a wow. Cambodia is $250. Philippines is about $180 to $200.
For tuition fee, Mr. President.
Yes. Brunei, of course, is subsidized totally. Myanmar is $85 per year. Laos is $203. These are the small countries. And it is reflected also in their foreign direct investment. Pareho rin ang ranking halos. We are second to the last or third from the last in foreign direct investments. Cambodia and Vietnam and Laos are the ones that are below us. No? And Indonesia is $157 per year. Big country, but mura. Vietnam is $200 per year. So, knowing that the tuition is low enough, and I think there is hardly any country in the world where it's easy to get into college. I mean, people have to know education is not cheap. It is, because if you do that, then it becomes again self entitlement, and I worry about that in our culture. There's too much entitlement in our culture. We're practically taking care of everybody, which is a good approach, but again, we end up asking for more taxes and to fulfill all the requirements that we want to give to our people. But also, we want them to know that they have to pay for it. For an example, that's a way upon which you educate them to pay their taxes. In Singapore, I believe after 6 years, or the moment they graduate, they have to pay within 12 years. So they pay right away. The moment they get a job, they have to pay, and of course, mababa sa umpisa. The moment they get a job, it's accelerated, especially because, Mr. President, it comes from the Central Provident Fund, which is totally protected by the Singaporeans, government and people alike. So it's important, I believe, that when we start thinking in terms of all these benefits that we're going to give, that it is inculcated upon our people that this is, it may be a study now, pay later program, but you want, that's why I say poor but deserving students. Somebody can be poor, pero ayaw mag-aral. Sayang naman yung pera. Bibigyan mo ng pera yung tao na ayaw mag-aral, may dapat merong standard siya na pag hindi ka nag-aral, sibat ka. Bayaran mo pa yung binayad sa'yo. And I think that's precisely sometimes what happens in many of our universities and our schools that are SUCCs also. So I'd just like to create that philosophy
Yes.
within the law.
Mr. President,
And I want to be it to be reflected in the debates, because should any of the kids research, this is not papogi or especially we are all aware of the circumstances why we suddenly have this windfall. Somebody saw that there was alam mo na, di ba? There was surpluses in the budget, and all of us have said, we all said in the room inside, said, hey, why don't we put it as free education?
Yes.
Nakakatakot yun eh. Because you cannot forever do that. And if we can keep on doing that, our people will no longer strive. It is succeed. It is, as they say in law, dura lex et lex. But here it is very, education is hard, but that is the way life is. You have
Yes.
to earn it.
Mr. President, if I may, firstly, thank you for your suggestions. Initially, in some initial deliberations, there was talk about providing a service clause to those who wish to receive free education, to put an X years of service clause there. We're not completely against that, Mr. President. I know that volunteerism is very close to your hearts, although that would be half volunteerism because may kapalit, which is, of course, the free education. No? So we can talk about that, Mr. President, when the time comes. Secondly, Mr. President, if you look at the statistics, very few of our students actually get to college. It's already hard to get to college.
Oh, I'm aware of that.
Only 4 out of 10 high school graduates, only 4 out of 10 students who enter our educational system
Grade
will,
one.
will step
And,
into college.
Yeah, I know. Yeah.
And only one of those, Mr. President, or a little over one, will actually graduate.
Mhm.
Now, Mr. President, the reason why the almost 3 will drop out of the 4 who enter college, it's because of financial concerns. And in short, Mr. President, our intervention is here to make sure that more of them actually graduate. No, the majority or the biggest concern, the biggest issue why people drop out is because they can't afford things.
I'm not
face-
sure I totally agree with that.
That's what the statistics say, Mr. President.
Well, statistics according to the Israeli, it doesn't mean it's the truth. It doesn't mean that that's the reality. The reality is that when somebody is entitled or feels entitled, he doesn't strive hard enough. Perhaps what is wrong with our educational system is the lack of a culture that says education is expensive. When I was mayor, I'm not trying to lecture here, I would tell the students in our high school, you take drugs, you die. Meaning I'm just saying, I don't care. You know why? Because this is a public school. Some others really want to get to school, but because of the entrance examinations, and you're smarter, when you don't use your talents, you deserve to be kicked out. Somebody who wants to get the education, who really wants it, will get it. And as you know in life, those who work hard, again I go both choy kang, both tansha, and I'm sure Sherwin will laugh again. If you look at our Chinese community, a lot of them do a lot of work, and they work hard. Some of them don't even have any education. But look at where they are now. Look at their kids. They have to go to London School of Economics. And sometimes I wonder whether we're not taking care of our culture that much, because the orientation is always like the friars of old, paternalistic, we should take care of our people. No, I think we should inculcate upon them the Protestant work ethic, that, you know, you really have to work hard. And if they, can you imagine, binibigyan mo na, hindi pa tatapos. Yun ang dapat pautangin natin. Kung talaga wala kang pera, di ibigay mo yung pera. Sabihin ko na, lahat ng gusto mag-aral, you have to keep up the standard in SUCC and the SUC. And if you don't work, you're out and you pay us for what you did not finish.
Mr. President, I'm amenable to that. If you wish
Yeah.
to discuss that later on.
No, I'm
maybe a
discussing
grade-
it now.
No, I mean, during the period of amendments, if you wish to suggest it as a grade requirement,
yes. And you're going to accept it?
I think, yeah. I
Yes,
think a lot of our co-sponsors and co-authors will be amenable to
I think there must be a philosophy of transformation rather than transaction. In other words, you want to transform your life, you have to get an education. And if you want to get an education, you're not going to get a free ride. You've got to work hard for it. Right? We
Yes.
are both fortunate. We went to the correct school. And I even got better in the better school when I went to UP.
I'm surprised you said correct, Mr. President.
Yes, because there are some schools that may not be as correct. As you can see, I mean, I'm just kidding. And this is levity, of course, but, you know, sometimes when it's too easy, like some famous personalities that are current right now, they go into a good law school and they lose their way. They get blinded by entitlement. It's my chance to get money. Others are doing it. I'm entitled to it too. So they even wait 9 hours in a hotel to get money.
Yes, Mr.
And they
President.
go back and forth to continue asking for money because the principle is get rich fast. Not if you work, you get a better life. If you study, you get a better life. So I think in our laws, I think we should never forget that that is what our country must be. A country that exacts, you know, work, save, invest, prosper.
That's wisdom, Mr. President. And
It's not wisdom.
At the
it's
right
what our
time, we
parents teach
will
us.
include that, Mr. President.
You
Maybe
came
a
out-
grade requirement.
You came out to be a very good man. I know your dad. He was ahead of me in school. And your mother, I think both of them, I don't know your mother that well, but of course, you came out that way because that was inculcated upon you. The values.
Yes, Mr. President.
And not the money, not the numerical number. We have a lot of our colleagues here who went to public schools, but they excel better than those who went to Ateneo or who went to so-called, you know, schools like La Salle or San Beda or whatever. Those guys that really deserve it are those that work hard, and it doesn't matter where they go. It is not the school, it is the personality, and that must be translated in our bill.
Yes, I agree, Mr. President.
Thank you. You have good taste. And having said that, Mr. President, I also would like to ensure that this bill succeeds and it doesn't become a time of entitlement na nagkaroon tayo ng pagkakataon, nakakita tayo ng pera, sinaksak natin kagad, tapos pagdating sa bandang huli, bakit ang dami pa rin hindi nakakatapos? There's no excuse.
Yes.
There's no excuse. You know, how many people do you know their parents sell their Carabao to go to nursing school? And when they graduate from nursing school, uutang pa. 3 review course ang kukunin para makapasa. There is no question about the desire for education. There is question on those that feel that there is entitlement. That is why they drop out. So I don't buy the argument that just because they don't make it to higher education means that it's because of lack of money. I know many people who don't have any money but succeeded in life nonetheless because they were driven. And that is what, as Committee on Education Secretary and as a member of that, we must work hard in the grade school and the high school. It's too late when they get to college. And on that note, Mr. President, I will thank you for your patience.
I'd like to thank the gentleman from Olongapo as well for
From
all of
Zambales.
his from Zambales for his suggestions. In fact, at the right time, if we are to introduce a grade requirement provision here, I would be very amenable. I'm hoping my other co-sponsors and co-authors will also be amenable to that reform. Thank you very much, Mr. President.
Thank you very much.
Thank
Indeed.
you. The Majority Leader.
Mr. President, there are other senators who signified to interpolate at a later date. So I move to suspend consideration of Senate Bill number 1304 under Committee Report Number 28.
Any objection? Consideration of Senate Bill 1304 is hereby suspended.
Mr. President, with the permission of the body, I move to resume consideration of Senate Bill Number 1233 under Committee Report Number 8.
Any objection? Hearing none, consideration of Senate Bill Number 1233 under Committee Report Number 8 is in order.
Mr. President, this is the measure on creating the Coconut Farmers and Industry Trust Fund. The parliamentary status of the measure is that we are still in the period of interpellations. May we then recognize the sponsor, the chairman of the Committee on Agriculture and Food, Senator Francis Pangilinan.
Senator Pangilinan is recognized.
Yes, thank you, Mr. President. Thank you, Acting Majority Leader. We were conferring with the Acting Majority Leader, Mr. President, that while there are reservations for interpellation, and we are here ready to be interpellated, a number of our colleagues have requested that they proceed with their interpellation next week. And so we would just like to place on record that, well, we are here, Mr. President, ready to be interpellated, but considering that some of our colleagues would like to have it rescheduled to next week, we have no choice, but we will be ready, Mr. President, next week, Monday. We hope that this can be again placed at the upper number, or the lower number rather, of the agenda, so that we can tackle it, Mr. President.
Mr. President, with the consent of the sponsor, on record, I move to suspend consideration of Senate Bill Number 1233 under Committee Report Number 8.
Any objection? Hearing none, so suspended. Yes, Senator Pangilinan.
Yes, just for the record, if I'm not mistaken, we have 4 more or 3 more, at least based on the agenda, 3 more interpellators. These are Senators Recto, Gordon, and Pacquiao. And Escudero.
So yes, we confirm that Senator Pangilinan, there are 4 who have manifested their desire to avail of the period of interpellation.
Thank you, Mr. President.
Recto, Gordon, Escudero, and Pacquiao.
That is correct, Mr. President. Mr. President, with the permission of the body, I move to resume consideration of Senate Bill Number 1271 under Committee Report Number 17.
Consideration of Senate Bill 1271 is in order.
Mr. President, this is a proposed measure on the Anti-Discrimination Act. The parliamentary status of the measure is that we are now in the period of interpellation. May I move to recognize the sponsor, the chairman of the Committee on Women, Children, Family Relations, and Gender Equality, Senator Risa Hontiveros.
Senator Hontiveros is recognized.
Thank you, Mr. President. Mr. President, based on my earlier discussion with the acting majority leader, though Senate Bill Number 1271 is scheduled for continuing interpellation today, no one has registered to interpellate. I'd just like to put it on record, Mr. President, that this is the second session day that Senate Bill Number 1271 has been scheduled for continuing interpellation, but no member of the chamber has scheduled to interpellate.
Mr. President, with that on record, we conferred with the sponsor, the good sponsor, and we sought her consent that Senators Pacquiao and Villanueva would like to interpellate at a later date.
I confirm that, Mr. President, and I merely requested the acting majority leader that the continuing interpellation of Senate Bill Number 1271 be scheduled soonest, so that I can respond to the questions to be raised by Senators Villanueva and again Pacquiao, so that we can move forward on this bill. Thank you very much, Mr. President. Thank you, Majority Leader.
Mr. President, with the consent of the good sponsor on record, I therefore move to suspend consideration of Senate Bill Number 1271 under Committee Report Number 70.
Any objection? Hearing none, consideration of Senate Bill 1271 is hereby suspended.
Thank you, Mr. President. Thank you, Mr. Majority Leader.
Mr. President, there being no other matter, I move that we adjourn the session until 3 o'clock in the afternoon of Monday, 20 February 2017.
Any objection? Hearing none, the session is adjourned until February 20, 2017 at 3 o'clock in the afternoon.